Hello, everyone, and welcome to this event in partnership with Syracuse University, Whitman School of Management. My name is Stefania, and I will be moderating this masterclass on behalf of Docsity. So I see here that our first participants have joined us, so a warm welcome to all of you. Before we commence with our session, we will take a few moments to allow everyone to connect. While we wait, please feel free to say hello or introduce yourself in the chat. Additionally, we're quite interested in knowing where are you joining us from. So please take a moment to share your location here in the chat that you find on Zoom. And thank you for being part of this masterclass. And we will commencing shortly, I swear. Meanwhile, I like to take this opportunity to let you know that we have a Q&A session scheduled immediately following this presentation. So this is your moment to engage with our panelists, so please feel free to share your questions and curiosity in the Q&A box. We will be thrilled to answer them at the end of this presentation. And also, last but not least, if you're interested in receiving the certificate of attendance issued by Docsity, please stay tuned because we will give you more information after this session. And talking about the lineup, today we will talk about the law of personal injuries in business and how torts affect business with the real cases and the risk management insights. So addressing us on this will be John Petosa, JD licensed CPA and attorney who currently serves as the CFO and General Counsel of Food Distribution in Syracuse and teaches law, accounting, and entrepreneurial classes. So thank you again to being part of this event. And without further ado, we can get started. So John, the floor is yours. Welcome.
Thank you, Stefania. And welcome to everyone. Thank you for taking some time out of your day to listen to me talk about the law of personal injury in business. We thought that this might be a nice topic for some of you involved in the business world. This is an area that in my past life as a CFO and general counsel for this food distribution company, this is the kind of stuff that kept me up at night, the things to worry about, right? Because the law of personal injury changes on a frequent basis, and there's new and different things that have to be considered by all business managers. And so that's going to be sort of the topic that we're covering today. Just a little bit about me. As you can see on the screen, I'm an attorney. I'm also a CPA. I'm also a chartered global management accountant, which I guess just means that I'm really old. I've been a professor of practice at Syracuse University for 20 years now, teaching in Whitman School of Management and also our law school at times, teaching business law, introduction to business, various accounting classes. And additionally, just for fun, I'm the judge in the town where I live in Camillus, New York. I do understand that many of you might be on here from around the world. I'm going to speak to you about the law as it relates to the United States of America. It'll be interesting if you want to put in the chat how things might be different where you're located. So again, that's me and what I do. One of the things that we're going to talk about at the end is some really interesting cases that I think you may or may not be familiar with. Of course, one of the most famous cases that we have in the area of torts or the law of personal injury is the infamous McDonald's case where the young lady went up and purchased a really hot coffee, spilled it on herself, and won a multi-million-dollar award. We'll talk about how that plays into the topic that we're discussing today. And of recent, 49 states sued Facebook, claiming that the content was intended to harm young people as an addictive sort of almost drug. Interesting. Why, as a business leader? Because it's the first time a case like that has been brought. And secondly, guess what kind of case it is? It's the law of personal injury, better known as torts. So we see that what I'm going to try to take you through is an introduction to torts. We have both intentional and unintentional torts. And so it would be important for me to give you background on how the difference between those two and the different kinds of intentional torts that may be out there. And then unintentional torts is better known as negligence or the law of negligence, where you didn't intend to, but you in fact did harm someone. So that's our agenda for today. I'll talk to you about the requirements for both intentional and unintentional, and then we'll go back and I'll mention some of these cases and why, to me, they might be interesting, and also maybe to you as potentially in your job and the work that you're performing, things that you might have to worry about. So first, elements of an intentional tort. So to prove an intentional tort, the most important part is intent. You have to have meant to interfere with someone's contractual right, or you had to have intended to harm them in some capacity. And we see that this can actually be where it's easy to see your intent, right? Actual, it could be implied, and it could be transferred, meaning that I could transfer my intent to someone else to harm them. It has to be a voluntary act by the defendant. So the person that is creating this tort has to have done it on their own free will. If for some reason they were required or forced to do this, then we lack intent. Always one of the biggest parts of all torts, both intentional and unintentional, is causation. And so as a result of the action of the defendant, it created harm, right? And we have this causation, this cause and effect, or what sometimes we refer to as the but for the actions, the person wouldn't have been harmed. And then lastly, as I've already kind of spoken about, have to have harm. No harm, no case. So let's talk about some of the different types of intentional torts. One thing that often goes together is assault and battery. And we tend to put them together, but we see that in the law of torts, they're two different things, right? Battery is an intentional, non-consensual, harmful, or offensive contact with the person. So battery means you actually have touch. Assault, by contrast, right? Intentional, non-consensual act that gives rise to the apprehension that a harmful or offensive act is imminent. Now, how do I draw this distinction? When I'm in class with my students and I can actually create a visual, what I would do is fake a punch at one of my students. Now, when I do that, right, that's actually assault. It's not battery. If I pull my punch short of that person's face, they have a claim for assault, right? Intentional, non-consensual act that gives rise to fear that they're about to be hit. Now, if I don't hold up and I follow through, then in that case, and I touch, now it's battery. Now, you can see where these two would normally go together. First, someone is in that imminent danger, and then there's actually a strike of some capacity. And so we see that in the typical, let's say, bar fight or some other sort of situation like that, where someone gets into an altercation and they're harmed, assault and battery go together. However, they don't need to. Conversely, if I have battery, I usually had assault before that. Another important one that we see happens in the business world all the time, especially in retail, is the idea of false imprisonment. So here we see that the elements are an intentional, non-consensual confinement by physical barriers or physical force, or the threat of force. Plaintiff must have been aware of and have suffered harm as a result of the confinement. So there's actually a case that I cover with my students where an elderly gentleman with a heart condition goes into a store. He came in with a scarf, and as he was walking out, one of the security people accused him of stealing the scarves at this men's store, forced him to sit in a chair and wait for the authorities to come. And while that was occurring, this gentleman had a heart attack. He sued the store for false imprisonment. And so we see, if you go through those elements, it may look like he has a valid claim for false imprisonment. This is the kind of thing that we would see in our courts all the time if the legislatures in most states hadn't enacted legislation that exonerates retailers in many of these circumstances, as long as the confinement is reasonable. If you were to be accused of shoplifting and they handcuff you to a chair, it's probably not going to be considered a reasonable approach if you've been cooperative with someone. Not sure about you guys, but I know every time I go to a certain store and they have those electronic monitoring devices that the clerk always forgets to demagnetize or pull apart, it's a pretty uncomfortable feeling when you go through the magnetometer and the alarm goes off. I think we as a society, though, are so immune to it that usually the clerk just sort of waves you on. But there's certainly that pause. I know I have it. I'll bet you do too when that alarm goes off. But businesses have to consider this, right? Should they allow their employees to interact with the customer in a situation like this, or should they just call the police? In my position as town judge, I have a Walmart in my town. It probably accounts for over a third of the activity in my court. And Walmart has a policy where their asset protection people, as they call them, they are not allowed to touch or forcibly restrain anyone. They try to use voice commands, and if the people are cooperative, that's great. And if not, they write down descriptions, write down license plates, and they call the authorities for assistance with matters like this. So the idea of retailers and shoplifting, false imprisonment, is something that you and I as business managers have to think about and consider. As of late, here in the United States, a number of larger cities have moved to decriminalize some of these actions. And so this is becoming a more pervasive problem for big retailers. There was just a situation yesterday where individuals were stabbed in Philadelphia at a Macy's. And so I think that this issue is going to come up maybe to the forefront. So those are sort of physical torts, right? And torts to protect people. Let's talk about torts to protect privacy. And I'm really going to be curious, since we have a global audience here today, in your questions in the chat. I think that this would be interesting because the laws in the United States are significantly different than the laws in Europe. I am familiar a little bit with the European Union, and privacy is taken to a much greater extent than maybe what we have here in the United States. And so one intentional tort, right, is the invasion of privacy. It says violation of the right to keep personal matters to oneself. Here again, is that Facebook issue that you have all of this information. How much of it should you share? When should you share it? Should you share it at all? And so we see that another element of the invasion of privacy is an intrusion, meaning an objectionable crime. I always point out to my students that, and I'll bet you folks do the same thing, when you get that terms and conditions of use, where the print is about 6-point font and no one can really read it, and it's long, and all you just want to be able to do is use the app or use whatever it is that you're going to sign up for. Most of us kind of skim through that stuff, but I'll bet if you read it, you'll find lots of points where you're giving up your right to this objectionable crime. There has to be a public disclosure of those private facts. I'm sure that you've read in the news about these different data breaches where people have gone in and stolen data from various places. Clearly, these are tort actions, right? And invasion of privacy. Let me just sort of add in here that it's very interesting where I sit as a judge. Not only do we have to consider the civil side of this that we're talking about today, right? All of these intentional torts, but you should also keep in mind that the criminal side of this very closely mirrors the elements that we're talking about on the civil side. And so not only in the United States can I be charged civilly, I could also be charged criminally from my actions. Of course, the key being I have to be caught. And we know that with some of these public disclosures, with the data breaches, we've never been able to find the perpetrators because they may reside not in the United States, but someplace else. And so, as I've noted here, this Meta and Google lawsuits, Google was just recently sued, I believe, by the European Union and also here in the United States for how much information they might be sharing. And of course, Meta, the parent of Facebook, also has had some difficulties here of late as to the amount of information that they're sharing with their various advertisers. Another example of this would be the appropriation of a person's name, image, or likeness. And here we see that the defendant appropriated the plaintiff's name or likeness and can be identified. This is an area of law. Let me give you another little segue why I love the law. It changes all the time. And so as our society changes, as our beliefs change, as our technology changes, so does the law. But usually it's not ahead of those changes. The law usually follows in many respects, either from a legislative standpoint or from court or judge-made law. Here we see that I can foresee AI becoming a real problem as it relates to misappropriation of a person's name, image, or likeness. I'm sure you guys are all familiar with the idea that AI can mimic your voice, mimic your face. And so here we see another area of the law that may come into greater prominence here in the near future. Conversion is also considered a tort of privacy. This is where you take the property of another person. I have a really neat case that occurred in my court where this party was running a diner. They decided they didn't want to do that anymore. They leased out the diner or subleased it to another party. And then that other party was not doing a very good job. It was reflecting on the first party. And so the first party shut down this sublease. And the for party one basically stole all of party two's kitchen equipment. And when party two kept saying to party one, I want my stuff back, there was constantly excuses. And believe it or not, they had to come into my court for that kind of decision. It's an example of this privacy tort or tort of property in this case. And I, of course, found for the party that lost their property. So not only can we have torts against people and our personal property, but we can also have contractual torts. And so torts is such an interesting area of law to practice in because, as I indicated, it overlaps with criminal law in many respects. It also overlaps significantly with contractual law. And so we see that one of the main torts in this area is interference with a contractual relationship. And this is where the defendant intentionally induces another person into a breach. Recently had a case with a client where she was working for an insurance agency, and the insurance agency made her sign a non-compete agreement. It's a contract, right? And the insurance agent used this as a way to keep this person's wages down, because the non-compete said that if this party left, that she had to pay her former boss 60% of whatever she generated as a damage from the new employer. And this is a person who isn't making a lot of money. And so this was rather onerous. The threat by the insurance agent was that this other party that stole away his employee, they were potentially going to be sued based on this intentional tort theory that the second agent actually induced the person to leave the first party and come to the second party. And so an example provided to you. We also have interference with a prospective business advantage. And here we see that the plaintiff has to prove the defendant interfered with a relationship that the plaintiff sought to develop. And we can see this in our business situations where maybe we're going to hire someone to perform some work for us, maybe make some repairs, and someone stepped in and talked bad about that party, such that we didn't select them in the end to perform that service. And we also have, as part of this area of intentional torts, the idea of bad faith, that you appeared that you wanted to enter into this contract, but it was really done for some other reason, maybe to stall or cause you to your business to fail. So maybe we engaged in negotiations for the purchase and sale of a business that was struggling. And at the end of the day, it was really just a ploy so that you could get a free look, get the customer list, and then ultimately back out of the deal, causing that party to fail. That could be a potential example of a bad faith action. All right, let's take a quick breath. And what we're going to talk about next is negligence, or the law of unintentional torts. So all of those intentional torts, we can see them. We see them coming. We understand that our actions have consequences, and the law is fairly clear. What's interesting about the law of negligence is we are constantly coming up with this first element here, duty. So again, unintentional, there's no intent required for negligence. And we have to have these four elements for a cause of, for a claim of negligence. And so we have to have a duty, meaning that we, the defendant, owed the party some kind of duty. We breached that duty, meaning that we failed to provide or protect or whatever the implied duty is. Again, we have to have causation. Here we have to have not only the actual cause, but also the proximate cause, or an easier way to think of that is foreseeability. And then again, just like in the intentional area, we have to have damage or injury. So let me give you an example to maybe illustrate the law of negligence. So as I noted, I've been at Syracuse University for 20 years. And if you guys aren't familiar with the city of Syracuse in upstate New York, it is the snowiest major city in the United States. We average somewhere around 200 inches of snow a year. And so it would make sense that we're usually pretty good at plowing streets and sidewalks. Well, hopefully you can appreciate and agree with me that Syracuse University owes me a duty with regard to snow removal. And while You won't find it anywhere in any handbooks. There's nothing that I've read that says Syracuse University will clear the sidewalk so that I can get to class in a timely fashion. I think we would all agree that Syracuse owes me that duty, that as a responsible employer, open to the public, that not only do they owe that duty to me, but also to all of our students. And so that's the hard part about the law of negligence is these are things that we think are appropriate. And so these duties are constantly being created via lawsuits and challenged at times. So if we can agree that Syracuse owes me this duty of clearing the sidewalk, maybe putting a little salt down to melt the ice that occurs through the constant winter season that we have. On this one particular day, about 2 years ago, for whatever reason, the sidewalks were not clear. And I was walking up to class, zoop, slipped, fell, boom, down I went. Yard sale, right? Book bag, papers, everything flying around. Students looking at me, laughing. We've established the duty. Hopefully, I've now established a breach of that duty, right? There was no plowing that occurred that day for whatever reason. Causation. Was the reason I slipped and fell a result of the university's failure to provide this duty or care? I think that it was clearly the actual cause. I've been walking for a long time on this earth. I have a pretty good idea of how to walk, and I also have a pretty good idea of how to walk when it snows in Syracuse. I've lived here all 58 years of my life. And so I think that's reasonable to connect this, right? But for the ice on the ground, I probably wouldn't have slipped and fell. Was it foreseeable that if the university didn't clear this sidewalk that I would probably slip or someone might slip that day? I think it's foreseeable. Therefore, I've established the proximate cause as well. And so what's left? Damages. Well, thankfully, I took a little check and we can establish that I'm just fat enough because there was no damage. I was not harmed in any way. And so hopefully I've established for you that I can go through all of the other elements of a claim for negligence. But if I wasn't hurt, no damage, no cause of action. Okay. So as we go through these different types of scenarios here for negligence, sort of keep that in mind, these four elements: duty, breach, causation, which I break into two parts: actual and proximate cause, and then, of course, damage. And so we see that we have a duty, and it depends on oftentimes the type of duty that we have. You see, I've listed trespasser, licensee, invitee. In my example that I gave you, I'm an invitee of the university. So when I own property, so if I'm a business owner and I have property and I invite people to my facility, I owe them a particular duty of care. A licensee, it could even be argued that I, as an employee of the university and my licensee, I have an affirmative right to be there to perform on my contract. Maybe that duty of care is even higher. The least amount of duty that we might owe is to a trespasser. So if someone is on our property illegally, then we probably don't owe them to clear our sidewalk. Another example that you might have in your mind is if I owned vacant land. Quite frequently, you'll see signs that say posted. What are they trying to post you of? They're trying to warn you that this is private property and that the owner is not responsible for whatever those losses might be. If you trip and fall, you get attacked by some kind of wildlife, the landlord is putting you on notice. You're here at your own risk and you're a trespasser. So many of the things that we learn as managers under this law of negligence is how can we protect ourselves from someone suing us for failing, in this case, our duty. Again, the breach is a general standard of conduct. We often focus on what would the reasonable person do. In my example, I think you would agree that the reasonable thing for the university to do would be to clear the sidewalk so that people can get to class or get to work or do whatever it is that they need to do. And again, that the breach occurs when the conduct of the defendant falls below what you and I, as reasonable people, would think is appropriate. Again, there has to be this causal connection. The actual is that but for idea, but for the sidewalk not being cleared, I probably wouldn't have fallen that day. And then again, foreseeability. This is a situation where we put a little bit of limit on the defendant's liability. If it wasn't foreseeable that this might happen, then in a situation like that, there probably wouldn't be causation. And of course, last but not least, injury. Have to have harm. No harm, no case. So hopefully I've scared you a little bit, right? Because now we know that there's plaintiffs' attorneys out there looking for opportunities. You've probably seen some of these plaintiffs' attorneys on television or maybe on your podcasts or whatever, right? Advertising. If you've been hurt in a car, call this particular person or call the heavy hitters, or we're here to get you your maximum payout. All of those lawyers operate in this area of personal injury or torts. So how can we defend ourselves from this? Well, one, take those reasonable steps. Two, maybe we have people sign away, have a waiver, sign a waiver that you're participating at your own risk. And we have a few concepts in the law that help protect property owners, employers, landowners, homeowners. One is what we call contributory negligence, and the other is comparative negligence. Contributory can be something of a harsh concept, and this in the United States is sort of a state-by-state approach. So as you read what I've written, right, it says if the plaintiff is negligent at all, he or she recovers nothing. So one of your defenses would be, if you're Syracuse University against Petosa, or Petosa versus the Syracuse University, probably not a career advancing move, by the way. But if I was to sue my employer for slipping and falling, they might say, well, Petosa didn't have boots on that day. And everyone knows that if you live in Syracuse, you've got to have proper footwear. And I had my sneakers on, and so I contributed to this situation. If the law of New York said any amount of contributory negligence involved, and so the Syracuse would prove that, I would recover nothing. A much more common approach in these kinds of cases is what we call comparative negligence. And here, the university would say, okay, you're right, we didn't shovel that day. We had a bunch of people calling sick and we fell behind and the snow happened all at once. But Petosa is partly wrong from a comparative negligence standpoint because he did not have the appropriate footwear. So if he's 30% responsible, we'll take the other 70% and maybe we'll settle our claim that way. So hopefully that makes sense to you. Contributory, if you're any amount contributory, generally you get no recovery. Comparative, you'll get something less whatever you contributed to this. If it's 50-50, however, you're out of luck. Another really big defense is what we call assumption of the risk. So another thing that you probably do in your general life is you'll buy tickets to a show or maybe an amusement park, and I'll bet you've never read the back of that ticket. And I also bet you probably have never looked up here to the left or the right and see a big sign that says, warning, you participate at your own risk. These are, in effect, waivers. And we see assumption of the risk is where you knew the risk was present, you understood the risk, and you went on Space Mountain and you had a heart condition, and you voluntarily chose to incur that risk. Assumption of the risk is, in effect, a contributory negligence theory. How's this play out? So I've written down here Coomer versus Kansas City baseball. So for those of you that don't know, the Kansas City Royals play baseball here in the United States in Missouri. And there was a fan who went to the game. His name was Coomer. And Coomer was sitting in the stands, minding in his own business. And one of the, I guess, acts of their mascot, I think the mascot's name was Homer, he has a air gun and he fires hot dogs into the stand. I'm not making this up, by the way. It's an actual case. You can look it up. And so the mascot fires this hot dog into the stands. Coomer's not paying attention. It hits Coomer in the eye and detaches his retina. A freak accident. The Kansas City Royals defense was assumption of the risk. When you go to a baseball game, you assume that there's bats and balls and stuff might happen at a Major League Baseball game where you might be harmed. The hard part here is, was it reasonable for Coomer to think that he might get hit in the eye with a hot dog? And as you can imagine, this actually case went back and forth on a number of different issues, but Kansas City ultimately lost here. That, you know, when you go to a baseball game, that's just not something normal. Okay. So those are some different defenses to a claim of negligence. Now, certain activities we have, and it's what we call strict liability. And this is, we think that this activity is just so dangerous that we have to put all of the potential damage on the defendant. And the best example that we have here in America is something called workers' compensation. So every employer has to have an insurance policy that if their employees get hurt at work, the employer is just absolutely responsible. And some of this is not necessarily because the employer's actions are dangerous. This became more of a public policy concern, right? Do we really want people suing their employer? As I noted before, not a career advancing move if I sue SU about slipping and falling on the ice. They may terminate my contract for something like that. But as an employee, if I'm hurt at work, then I would be covered under this policy, and it doesn't matter. Any of those defenses of contributory, comparative negligence, assumption of the risk, in our here in the U.S., we make it so that the employer is absolutely responsible for their employee, and it's a form of strict liability. Another example that I can give you to explain this concept is, let's say that we are in the construction business and we implode buildings so that we can rebuild on that piece of property. There's blasting would be an example of, if any amount of harm comes out of that activity, the blasting company is going to be strictly liable for any damage that might occur. So strict liability, again, your eyes are wide open as the employer. You know that you're going to be responsible in some capacity. One last concept before I kind of talk a little bit about current events is the idea of respondeat superior and vicarious liability. And so, again, as an employer, I'm responsible for the actions of my employees while they are in the course and scope of employment. This kind of stuff would scare the heck out of me, right? So when all of my drivers and employees are out there working for me, delivering product, what are they doing that we might be held responsible for? I've got commercial truck drivers driving vehicles that weigh, well, it's measured in the tons, right? And what are they doing? How are they driving? Are they driving while intoxicated? Are they not paying attention to the road? Are they being distracted? They could potentially hurt people and cause us a big problem. And so this concept came out of a very old law that we stole, of course, from England when this country was founded. And the idea was a master and a servant, which we now call employee and employer. And again, this concept is that let the master respond. So respondeat superior is a claim that while this individual may have created the harm, the employer is responsible for that loss. My example is that one of my truck drivers wasn't paying attention. He was on a really close bridge, and there was someone riding their bicycle on this bridge, and the truck hit this person on the bicycle. Now, the bicyclist could have sued my truck driver, but while I paid him pretty well, he didn't have necessarily an awful lot of money to take care of the medical bills of this person and lost wages, etc. And so, of course, the bicycle person sued our company. How do we protect ourselves? One, we talk to our employees all the time about safety. Two, if we could, we get waivers in particular situations. This was not one of those examples. Three, most importantly, probably, we have insurance. And so we purchase insurance so that we can protect ourselves from these kinds of situations. Examples. I've got about, I think, 2 or 3 minutes left. McDonald's around the world, hot coffee. And one of the probably most famous suits, we had a woman who purchased a coffee. She then put that coffee between her legs from the drive-through and drove away. The lid came free, and she got third-degree burns in places where you wouldn't want to have third-degree burns. Trial court awarded her well over $1 million for these burns. So I would tell you that on appeal that it was greatly reduced, but the key is, what do you do as a business owner in a situation like this? And if we could converse, I'm sure you would tell me, now when you purchase that coffee, first of all, McDonald's doesn't make it as hot as they used to. And if any of you are coffee drinkers, usually the hotter the better. Two, they put warnings, right? Warning, hot, matter, drink carefully. One of the ways McDonald's actually was able to beat this suit down to a much more manageable number was comparative negligence. In this particular situation, it was found that this woman added to the problem by putting the coffee between her legs rather than having it in her cup holder. Again, we have this situation where Facebook and Instagram have been sued, or Meta have been sued by various states, 49 to be exact, claiming that the material that they have on their social media website has been damaging to young women, and that they are causing intentional and unintentional harm to young people, and again, specifically women in the United States, because of the shaming and bullying that occurs on these social media websites, and that they know about it and they're allowing it to happen. And so this is a relatively new suit. Again, it falls under this topic that we're covering today. You may want to follow along and see what happens in this suit. Another case that I like to talk with my students about is how this idea of torts also comes into public policy. So we had a in the northern part of New York State. It's rather remote. A company was trying to build a facility in this remote area, and they were providing money for their employees to stay at this remote location because most of the employees lived a fair distance away. And there was one official of the company who told the employees, if I were you, I'd probably drive home every night and I'd just pocket the money. And so, of course, there was a car accident and someone lost their life, and there was a wrongful death suit, and they brought it against the company. And the question was whether the company had a duty of care to their employees to force them to not drive home. And this particular case found that that duty did not exist. But you can see how I offer that to you to consider, hey, these things are changing all the time. And last but not least, when I woke up this morning, there was no news about the opioid crisis here in the United States and how one particular company had filed bankruptcy and they wanted to settle all their claims. This is not a talk on bankruptcy, but the opioid settlement was in fact a tort lawsuit brought by a class action settlement for many of the parties, individuals who have become addicted to opioids for various and sundry reasons. So that's my discussion. I guess we'll open this thing up. I'll stop my share and we'll open this up for questions, right?
Right, Professor. So we have few questions. Thank you for your presentation. And now let's go to the Q&A session. I remind you, the students, that if you want to drop now a question in the Q&A box, you still have time. So let's start with the first one that is saying, hello, Professor. Do you think it's true that there is an industry of injury claims, like people making them up to earn money?
Well, I guess I don't know if there's an industry for this, but I guess you could make that claim that the legal profession certainly is looking for plaintiffs. They're doing an awful lot of advertising on different platforms in an attempt to get people into their office. I guess I would say to you that not everyone is scrupulous when they make these kinds of claims, but part of the lawyer's responsibility is to investigate these claims prior to bringing it to court. If, in fact, the lawyer brings a claim that is just totally fraudulent, the lawyer can get in a lot of trouble. In fact, even maybe being disbarred. So I don't know if there's a fraudulent injury claim industry, but certainly fraud is a part of this at times.
Okay, thank you, Professor, for your point of view, your explanation. The second question is, do you think that the unions in the US do a good job in controlling the safety of the working environments?
Ooh, that's a hard question. I guess short answer, I'll say yes. I think that unions certainly have that role where they're looking out for their workers' best interests. I would also share with you that there's an awful lot of laws on the books protecting workers and encouraging employers to be safe. There's also what we call OSHA, the Occupational Safety and Health Administration, governmental agency that investigates anytime there is a significant accident. And so that certainly weighs on employers' minds as well, trying to keep people safe. But is all of this perfect? Obviously not, because accidents continue to happen.
Sure. Okay, thank you. We also have a question about the type of insurance policies And they are asking what type of insurance policies are essential for businesses to protect against personal injury claims?
Yeah, so all businesses are going to have, if they own real property or rent real property, they're going to have a general liability policy to protect against these kinds of personal injury claims, right? Maybe somebody slipping and falling as entering the facility. As it relates to their employees, as I sort of indicated in my silly example, that they're going to have workers' compensation for any of their employees who might be hurt while they're on the job. Interesting lines of insurance have also developed, such as cyber security policies that would protect you from a data breach. And of course, most businesses would also have what we call an umbrella policy. So you've got your primary coverage, and then you'll have this additional coverage over the top, just in case that first, say, $1 million wasn't enough. Maybe you'll carry an umbrella of a couple $1 million.
Okay, thank you. And now going more deeper in the reality, they are asking, what do you think are the most common injuries to be taken to court? I guess in the US also.
Right. The most common, injuries coming to court are generally, I would say, slip and fall, car accidents. Those would probably be probably then medical malpractice would be maybe third.
Okay, thank you. Interesting. Okay, next question. Which do you think is the company with the highest safety score in the US and why?
Can you try that one again? Which do you think is the company with the highest safety score in the US? I would tell you not an area of my expertise, and so I don't think I have any idea. I'm not even sure statistics like that are kept at the governmental level. I'm sorry, I'm not able to answer that question.
No problem. I guess that was just a curiosity from a student, but thank you.
Yeah.
Let's go with this question. Professor, could you provide a brief historical context about torts in the US juridical system?
Where are you reading that one? Which one?
Is in the chat.
The difference between US and UK? Is that the one?
The historical context about torts in the US juridical system.
I don't see that. So try me again with that
Yes,
question.
sure. Could you provide a brief historical context about torts in the US juridical system?
Historically, again, we borrowed our laws initially from England, and then over time have modified and adapted them. Maybe what you're asking is, this area of law comes from what we call the common law, meaning that it comes out of case law. So there's generally not statutes out there, although there are some covering this area of law. Most of it is cases that have occurred over time. And so those pieces of information I gave you, the elements of the different claims, that's developed over time out of cases. Hopefully I answered that. Not sure if I did.
Yes, thank you. And let's go with other questions in the Q&A box now. Do you think the resolution of personal injuries conflicts in court would be easier in a Roman law-based system?
Would love to, if this was sort of a live scenario, maybe that person could explain to me the Roman law-based system, how it might be different than our law here in the United States. I'm not familiar with what those differences might be. but would love to take a trip to Italy so that I could find out what those differences might be.
Sure, Professor, whenever you want. We are waiting for you here, especially in Turin, as you can see in the landscape.
Yeah.
So let's go on. Uh, Professor, do you think the companies feel they have to protect themselves more due to social media exposure? This is really up to date.
Yeah, I think that social media poses different problems for businesses. Right? Maybe if you terminate an employee in the past, they might tell a couple of their friends what a terrible place to work. But now the world is your oyster, right? You have the ability to sound off and tell the world that you don't like this place and this is what they did to you. And so, yeah, I think that companies have to take steps. Not uncommon for people to put in their handbooks, employee handbooks, that social media posts are unacceptable. Here in the United States, you have to be careful, right? Because we've got First Amendment rights to free speech. But certainly everyone has some sort of policy nowadays to address social media.
Okay, this was really interesting. Thank you. And we're going with the last question, but if you have, I'm talking to the students, if you have any other questions, please drop it because it's the last time that you can do it. So the last question is, what is the difference between the US and the UK in terms of stores? Is there a clear difference due to jurisdiction?
You know, this is, again, is not an area I've spent a lot of time studying. I do know that there are differences between the two. Am I able to articulate those to this person? I don't believe that I can at this time. I'd have to look into that and be able to provide a better answer. But I think this person's alluding to it. I do think there are jurisdictional issues that are different between the two countries, even though we stole their law. Oh, sorry, borrow.
Okay, so here we are. I guess that now we're done with the questions. So thanks again to our panelist, John Petosa, to be with us today. And thanks to everyone to have joined us today, to have been so curious and also responsive with your many questions. I hope you learned a lot about Syracuse University and that this masterclass actually help you to make the decision to study in this university or inform you more about this interesting topic. I'd like to remind you that now we are into the part of receive the certificate of attendance. So if you're interested in receive it, please click in the link that I'm sending right now into the chat. So here you can find it. And we will share the recording with you in the following days, so please keep an eye on the email. And finally, I would also ask to our panelists if you want to leave a message before saying goodbye to our students.
Thank you so much for your time and attention today and for the terrific questions. Hopefully, I'll see some of you in my master's classes that I teach at Syracuse University. It would be great to have you as a student. And happy holidays.
Thank you so much, Professor, and thanks everyone. I hope to see you again in the next webinar in partnership with Syracuse University. It was a pleasure for me to be the host of this webinar. Have a nice day. Goodbye.